So, welcome to another part of my series where I explain how to file for bankruptcy. Now, I'm going to make the same disclaimer that I always make when I'm going over these forms of the bankruptcy petition, and I'll put all the links that you need to know, and you can read the blogs about it as well on my blog, bankruptcy.blog. I'm going over the issues. And the reason I do that is simple. Anybody can complete any form, whether it's a bankruptcy form or a divorce case. It's very simple. It's just fill in the blanks, right? But that's not what's important. What's important is the issues. So what I like to focus on in all these is issues that you might come across, and I try to explain those issues so that your case will go smoothly. Okay, so let's first start off. You got to make sure, and let me go over here. You might be thinking, and it's common for clients to ask me, well, why does it matter what my spouse earns? Well, it is important because when they changed the law in 2005, they started to look into household contributions. So it could affect your bankruptcy case, but then when we get into the means test, if there's secured debts, I'll explain how to get around that. But just keep in mind that the court will consider that. Now, the advantage to that is if your spouse is unemployed, that might be the best time to file for bankruptcy, especially if you were close to the Chapter 7. Why? Because with Chapter 7, you have to do the means test, which is the average income in your state overlooking the last 6 months. Now, I've explained that a few times in the videos and for my blog, but part of the means test criticism is just that it's looking back at the last 6 months. So I always use as an example during COVID, people that saw me in December 2019 didn't qualify. All of a sudden, we're 2 or 3 months into the year. They're not working now. Maybe they missed 1 month or 2 months of paychecks, and automatically, what that does is lower their income over the 6 month period, and then they qualify. So if you're in that situation, sometimes people like to jump the gun and say, well, I don't qualify for Chapter 7, and they go straight to Chapter 13, knowing that their spouse was in danger of getting laid off, especially nowadays, unfortunately, where layoffs have become so common. So keep that in mind. And likewise, actually, I was mentioning COVID, but even this last time I was mentioning with the furlough of the airline industry, especially Spirit Airlines, now might have been the time to file for bankruptcy if they were in a furlough or if they were a government employee dealing with the federal government shutdown. Now, when we're going over the issues of income, here's what one thing you definitely have to be, you have to be careful about. Let me go right here. Insurance. Make sure that when you're doing this, you're going to go. Schedule J is going to be the next one that we go over. Schedule J is the expenses that you have. The problem with insurance is you have to make sure that you're not duplicating the expenses. So what if, your lawyer, for example, even you have to make sure that even with lawyers you don't make that mistake. Because sometimes on the intake they have a separate section where they go over expenses again and ask if there's insurance. That's how my intake looks like. So when you put yes and you put down $200, but you already put down $200 here, you're duplicating the expenses, and that's going to create a problem because the numbers don't match up. And we'll get into that at the end of the video, what kind of numbers you're looking for. Now, the same applies to domestic support obligations. What is that? Simply, we're talking about child support and we're talking about alimony. Those are domestic support obligations. So if either spouse is paying it, just make sure to include that. Why? Because again, it's going to change the numbers and it could help you pass the means test, and definitely this issue of disposable income with Schedule I. Now, do keep in mind that we're talking about here court ordered. So if it's not court ordered, you can still put that you're paying X amount. My only concern is if it's not court ordered and you're supposed to pay 500 and now you're paying 1,000, the trustee could object to that because the trustee would say that's fine that it's not court ordered and you had two parents who agreed. The problem is you're doubling, the amount, and there's no magical number, but just keep in mind that the trustee could object. Okay, and then back again just to make sure I went over that. Make sure when you're doing the health insurance, these are deductions that are made straight out of your paycheck. As you can see here, these are payroll deductions. So if it's not out of your payroll, then it'll be listed on Schedule J. But just make sure if it is listed on these expenses come out of your payroll, do not double the expenses on Schedule J, because then that means your numbers are off and you're not going to qualify for Chapter 7. At that point, you'll get pushed over to Chapter 13. Okay. Now, retirement plans, all this is basic, right? I really don't care what jurisdiction you're in. It's going to be the same for everyone. But here's when you have one of those exceptions: voluntary contributions. So, voluntary is clear. You're not required to do it. Here's the problem: every district is different. I have gotten away with clients paying more than $200 per paycheck, contributing to their 401k or IRA account. And guess what? The trustee didn't object. Then again, many years practicing there, you establish relationships and trust with these trustees. So maybe they let me slide. Maybe they wouldn't let someone else slide. But I can guarantee you that is not the case in every jurisdiction. I had looked this up when I was working on my textbook, Consumer Bankruptcy Law, and what I discovered was, yes, there are some jurisdictions that you take out $1 and the trustee is going to object and object and take it before the judge. So my district, I got away with it. Doesn't mean that you can be putting down 100, 200, $300 every single time. So what do you do in that scenario? Well, the answer is you have to know your district. And of course, if you never filed for bankruptcy before, that's going to be the issue: was how do I know my district? Well, you could try going through pacer.gov, and I'll put a link there that shows you real quick on my YouTube channel how to use Pacer. But you might be able just to go through prior attorney filings. Now, the first, don't quote me on this, I think $30 maybe that you use on Pacer, you don't have to pay for, but after that you will. But you're downloading petitions, which could be, dozens of pages. So you're going to go through that pretty quickly. I think there's a max of like $3 that they might charge per download. But what you're trying to see is how have other attorneys who are experienced in bankruptcy and have a lot of filings in that district, how are they handling the issue of voluntary contributions? So keep that in mind, because even when I relocated to the Jacksonville area, I knew I was in another world. Miami is different. Fort Lauderdale is different. When I practiced in Collier County, Naples, that was different. Every area is going to be different. I don't care if you're talking about bankruptcy court or if you're just talking civil court or just family court. It's all different. And so what I did was look at pleadings of lawyers filed, who already been practicing in that district for years. And I basically copied what they did. And then, of course, I adjusted everything accordingly to my client scenario. But keep that in mind. You might have to start doing some research to see what happens and how they handle retirement contributions in your district. Okay. Now, you see that these are expenses, right? But these expenses are kind of, we do the reverse as well. See if there's also the income side of it. So, for example, I mentioned um, uh, domestic support obligations. Well, here's your example. Are you paying domestic support obligations? Well, here it's asking you if you're actually receiving it, and you have to put that there. You're going to have to put it here because, again, that changes the numbers. All your income and all your expenses have to be clearly spread out on Schedule I and Schedule J. So not only are they asking you if you receive domestic support obligations, are you receiving unemployment compensation, Social Security? Social Security, let me hit this spot right now. When it comes to the means test, there is some forms of income that are not included in the calculations, but the means test is separate from Schedule I and Schedule J. J is expensive, I is income. And that's when they're going to look at the issue of disposable income. I mentioned that because when they changed the law, before it just used to be Schedule I and Schedule J. The means test was now another way that they were looking at your income. So now they're looking at your income twice. So just because you're on the means test and everything looks good, doesn't mean you're going to be looking good when it comes to disposable income. That's why they ask about this issue of whether you collect Social Security or not. So I'll give you the best example. Many years ago, I had a client who sole source of income was Social Security, something like $800 a month. Now, normally you would say $800 a month, that person's not going to have any problems qualifying for Chapter 7 bankruptcy. And the answer is absolutely correct. The means test doesn't have to be done. It's income that's excluded. And if it was included, it doesn't matter. We're talking $9,600 a year. So that's not an issue. The issue was her expenses. She was withdrawing money every single month, basically all on the same day, at the local casino that we have in Miami, Mikasuki. Well, guess what? I can't go to the trustee and say we can't afford to pay our bills here because she's spending her entire Social Security check at Mikasuki. Now, she lived with her daughter and husband. They took care of all the household bills, even pay the cell phone, etc. But there's your perfect example. That's not an expense that I could literally include every single month. Maybe one month I can get away with it, but not every single month. So if I wipe out if I have no expenses to show, what is going to happen? We have an $800 surplus. And then that means a person, as ridiculous as it sounds, has to go from chapter 7 to chapter 13. So that's why Social Security, you're going to have to put it there. It could affect ultimately disposable income. I've always said that the whole idea of the 2005 law change was to make bankruptcy more difficult for you. It was not to make it easier. And so that's why they look at your income twice. So even if it's government assistance, as you see it here, this is in the news now with the SNAP benefits and dealing with the government shutdown. They want to know about that too. So unfortunately, bankruptcy wasn't designed, to protect you, and it's very clear and documented that bankruptcy, this law change was really more to force people into Chapter 13, which means ultimately we were protecting creditors. Now, here's the important part. Now, I went over some of the issues you're going to face, and remember just to make sure you're not duplicating expenses and to put all other forms of income. Actually, let me go over this one real quick here. Other monthly income. If you have a family member that moves into your house, they are now contributing to the household expenses. Those contributions have to be included. And that can throw your numbers off completely. So imagine that, you move into my house and I say, well, I'll charge you another $1,000. That's $1,000 coming in. Unless my expenses on the household size on Schedule J increases $1,000, I have a problem. So keep that in mind. Now, your answer might be, or your question, how are they going to know? Be careful with that. I've had clients who, whether it's receiving mail at their house, that the trustee says, why is there a third party receiving mail at their house? One question leads to another. And then we quickly find out that there was a family member renting a room that was never disclosed. There could be deposits made. There's a million different ways to figure that out. So please be careful. When in doubt, always go to a lawyer who's experienced, will know how to work around this issue. But one thing I will tell you, do not lie to the trustee. If they want, they can refer you to the U.S. trustee's office. And now you're looking at bankruptcy fraud and you don't want to be there. Okay. Now, here's the part that was the most important. Schedule J, as I mentioned, was the expenses. When you're looking at all your income and expenses, I and J, what is the disposable income amount? And you see now how they're trying to get you twice, not only with the means test, but also now with comparing your income to expenses. So this you have to be careful, because if your disposable income is too high, guess what? You're going to be pushed to Chapter 13. As a general rule, I never had any problems under $100 per month. Districts change. But you might get to $125 per month, and you have a trustee that's going to start looking over all your expenses to make sure if your expenses are too high in order to force you into a Chapter 13. Now, what you have to keep in mind also is expenses change over time, and so does income. And so, if you're going to make any changes financially, please let your lawyer know. If you're not represented by a lawyer, then think twice about what you're going to do. I've had plenty of times that I tell a client that comes through the door and I said, I ran the numbers. You're good to go. You qualify for Chapter 7. They come back a few months later, to finish paying off their attorney's fees and court costs and with the credit counseling certificate. And then guess what I do when they come in, they make that final payment, I review everything with them again. So say, let's see what's changed in your financial situation. And they say, oh yeah, I forgot to tell you, my car payment, I don't want that car anymore. I got rid of that car. So that's a debt. Make sure you list that as a debt because I don't have the car. I already gave it back to the lender. That's great. The problem is if you had a $500 car note and now there's not $500 in your expenses, I got a $500 problem. So unless the income dropped $500, there is $500 left over. And that's going to push you from a 7 to a 13. So be careful when you make these financial decisions. If you are represented by an attorney, contact your attorney because a lot of times we might qualify you based on the means test, when we get to that, you're going to see that the means test takes into consideration secured debt. And if that debt disappears, then again, you may not qualify under the means test either. Okay. Any questions or comments, feel free to post them in the comment section below. I'll make reference to all these links. And remember, you can always go to bankruptcy.blog to see all the other blogs that I have on all the different sections of the petition so far. If not, just continue looking for it on the YouTube channel. There is a separate folder for that. All right, everybody, take care and best of luck with your bankruptcy case.